I am Terry Traveland. I am a volunteer attorney for the Small Business Development Center. If you are not yet a client of the SBDC, I highly recommend that you become one because it's a free service to help you start and grow your business. And they are very good at helping people grow. They have the resources to do that. They have the knowledge. And a lot of times in business, it's what you don't know that's going to take your business down. And so when you meet with them on a regular basis, they can issue spot for you things that might be a problem for you in the future. So I highly recommend that. Okay, let's see if I can, there we go. My background, I have a business background. I actually am an entrepreneur. I've had multiple companies. I had a chocolate business that I was actually a success story of the SBDC. I had a chocolate business that I started from scratch, and we were in the gift bags to the presenters at the Oscars. And then I successfully sold the business for the intellectual property that I had built up in the business. So, and then I mean, I barely had that one sold and I was starting another business. So when I give advice, it's because I have been there, done that, and have the t-shirt as well. My great grandfather started a business in 1934, and my grandfather built that up to 3 nurseries throughout Texas. And then my uncle bankrupted it, as often third generations do. And then my father started a business in 1973. I have worked every aspect of all of those businesses because as soon as I could start talking and taking out the trash, and I was the one that helped with the accounting because I was good with numbers. And so I can remember having to do, this was pre-QuickBooks, when you had actual physical journals that you had to write in the ledger, and you had to balance the columns going this way, and cut the vertical and the horizontal columns had to match. And I can remember trying to find the penny sometimes when we were off by a penny and going, Mom, couldn't I just give you one? Can I just give you the penny? And she's like, that doesn't work that way. So I learned a lot. We call it the family university. Business, family businesses are a great way to really teach your kids a lot about the value of dollar, sales. My niece is a veterinarian, and she's a very successful veterinarian because she learned sales skills working in the family business. So anyway, I'm a large firm trained attorney. I've been practicing for a long time, 27 years now. But the week before 9/11, I quit, and I was never going to practice law again. I hated it. I was exhausted because 8 years as a large firm attorney means about 15 years of experience condensed down into 8. So you work nights, weekends. It's a lot of work. And I was just done. And then the tech bust hit, thanks to 9/11. It was already started before that, but it just sped it up. And I was in the tech world for law. And so people started calling me, asking me, can you help me acquire a business? I just got laid off, or I want to start a business. I don't want to get laid off again. This is like the 4th time in 3 years. I'm so done. And I was like, oh yeah, I can, back of my hand, totally. I can help you with that, And the next thing I knew, I was practicing law again, and I loved it. And so my practice focuses on working with entrepreneurs to help them start and grow their businesses. And I have clients that I've had for more than 15 years that started with me as they were a startup, and now they're multi-million-dollar companies or more. And then I have some that started with me and are still small little consulting companies making, their 100 or 150,000 a year, whatever they want, and they're getting to go work, from a beach somewhere and enjoying that. So, it's all different types of businesses that I work with. Okay, there we go. So I'm going to jump right into employment law in Texas so that we can really get the most out of this. In Texas, we are a very business-friendly state, although it's being infiltrated by our legislators, who are starting to make it less and less so. And you'll see at the end of this presentation how that's occurring, because we have some changes that just came down and go into effect September 1st that are harsh for businesses. So we have what's called an at-will relationship in Texas for employment. And that means that you can fire an employee at any time for any reason, so long as it's not an illegal reason. Now, that doesn't mean that they can't file unemployment or sue you. It just means that you have the right to fire them at any time for any reason. But they can sue you if they believe that you fired them for illegal reasons, or if you had a contract with them and destroyed the at-will status of the employee. And that's really actually very easy to do. And so you have to be very, very careful to always stress, you're an at-will employee, you're an at-will employee. You know, so for example, these are things that have been found in court cases that have destroyed the at-will status. And the first is a probationary period. A lot of companies like to put employees on probation for 90 days to just see how they work out. 90 days was kind of done because it used to be that your health insurance had to kick in within 90 days, but now with Obamacare, it has to be 60. So, but they'll put people still on probationary period for 90 days. If in the offer letter, when you say that they have a probationary period for 90 days, you do not say, but you're still an at-will employee during that, and then kind of define what the at-will employee is, you have just guaranteed somebody 90 days of employment. Because you say you're going to be on probation for 90 days. That guarantees them 90 days of employment if you don't follow it with language saying, but you're an at-will employee. Okay. And we're not guaranteeing you any length of employment. And I'm not a fan of probationary periods, although I have some clients that prefer to do them, and that's fine. It's whatever your preference is. We work with it. I think it kind of hurts the morale because it's like, yeah, we want to hire you, sort of, but we're going to put you on probation just to make sure we want to hire you, right? So I don't think it's good for morale. You have at-will status. You can fire them at any time. If 2 weeks in, they're not working out because they can't get their butt out of bed and get to work by 8 o'clock and they're rolling in at 8:30, 8:45, 9 o'clock, 10 o'clock, you can still fire them, right? Because you have cause at that point to fire them. But even if they weren't, even if they came in one day and they had a tattoo that you were like, whoa, oh yeah, no, that's not going to work. Like that's no, like that's going to scare our employees, or it's going to scare our customers off because it's like some crazy like skeleton, something or other. I don't know. So if there was like this tattoo that would scare people, then you can fire them for that. If they walk in and you're just like, you know, I really don't like your shoes today, you can fire them for that. Or if you just get a bad vibe from them, you know, some people are like, yeah, they just like, I don't know what it is. I can't pinpoint it, but I just don't like his energy or her energy or something like that. You can fire them for that. You just can't fire them for illegal reasons, which we'll cover in a little bit. So at-will status. Now, just because you can fire them at any time doesn't mean that they can't file unemployment, and they can successfully do that if you fire them for a reason like, I just didn't like their energy, right? Okay, so other ways to destroy at-will status. Oh, I'm sorry, before I get too far, if you need a clarification of something that I'm talking about, just type it into the chat. I'm happy to clarify or whatever. And I have the chat up kind of in view so that I can see if there's anything that goes up. But if it's a question that's like specifically about your business, if you'll write it down and save it to the end, I'm happy to stay as late as y'all want. And I usually do, like, people open it up and they get on video, or they just open up their mic and ask their questions. And other people can listen in. If you want it more private, then you can, email me or call me at a later time. That's fine. Okay. This week is crazy busy for me. So next week is probably better for questions. Like, I'll put them in a folder and respond to them later. But you can email me now, or email me at then, and I'll just respond, but it might be this weekend before I get to respond, just because it's an insane week. I'm closing an $8 million deal. So that's why it's insane. Okay. So, other things that can easily destroy at-will status is statements in the employee handbook that like require warnings and reviews before you fire them, right? Like it's one of those, oh, don't worry, you'll know whether you're going to be fired or not, because we're going to give you plenty of warnings that you're screwing up. That's basically what it would say, right? And I put that in here because I see this so often. People will hire an HR company to come in and do their HR. And they'll be like, oh, well, you need an employee handbook. And you go, great, give me one. And then you never read it. And then, and just so you understand, the employees aren't going to read it either. They're not going to read it. They never do. They'll sign that they've read it. They will swear to you that they've read it, but they are not going to read the employee handbook word for word. The only time they go back and read the employee handbook word for word is when you fire them and they want to see if they can sue you. That's it. So that's when they do it. And then they find out, oh, wait, we were supposed to be having annual reviews, or every 6 months we were supposed to be having reviews. They never did those. They didn't even follow their own procedures on how to fire somebody. It's set out here in the employee handbook, and they didn't even follow their own employee handbook. And that's problematic. That's when it's a big deal. And so that's when you can destroy the at-will status, because you didn't follow the proper procedures. So the moral of that is, one, don't put that stuff in your handbook if you're not going to follow it. And two, read your handbook. Make sure that it works. I mean, I was reviewing somebody's handbook the other day, and it was like, oh, our hours are from 10 in the morning until 6 at night. What? No, y'all are open at 7 a.m. and you don't close till 10. Like, they didn't even have their correct hours in their handbook, right? Because they didn't read it. So you definitely want to do that. Okay. Other things would be something like statements in an offer letter, like, for the first year, you're going to make $70,000. And that's it, right? In the offer letter, you want to have an attorney draft your offer letter for you, because you want to make sure you get it right for what you need. And your offer letter is going to look very different than somebody else's offer letter. They're going to have some common elements, but they're going to look different because you may or may not offer benefits. You may require a probation period. You may require training or certifications or things like that. And so there's going to be differences in that offer letter. But they can give you a basic shell offer letter that would work for your company, that you can then modify for most employees unless you do something special. And that's when you go back and talk to your attorney, like, we're going to hire a CFO and he's wanting ownership in the business. That's when you go talk to your attorney, those types of things, when you have special circumstances, and then they can help you with that as well. Okay, so in the offer letter, this is a case where, just so you understand, the judges and the juries are going to try and find for the employee if they can, because you're the big bag company, right? You are horrible corporate America that mistreats all of the employees. That's the way they look at it. And so they're going to try and find that. And so everybody knew in this offer letter what they meant, which was, you're going to make $70,000 per year, and it's going to be like, per pay period kind of thing, that, it's going to be divided up among our regularly scheduled pay periods, etc. But they didn't say that. They said $70,000 for the first year. And the judge said, oh, you guaranteed them a year of employment. You guaranteed them $70,000 for the first year. I'm surprised he didn't say, well, that first year implied that there would be a second year, so you guaranteed them 2 years. I mean, because he could have. So you really want to make sure that your offer letter says like what their annual salary will be or what their hourly rate will be. And we'll go over which one you're going to want later. And then it's going to say payable in installments, like biweekly, monthly, every other week, whatever, how weekly, if you pay weekly, however you do your payroll practice, installments with the applicable deductions for federal taxes, federal income taxes, FICA, etc. Okay. So you want to make sure that that's in there. You want to make sure that they understand that you're taking out those taxes for them. You would think that they would understand it, but they don't oftentimes. So by that same token, if you have things that you may end up deducting from somebody's payroll, like their uniform, like if you supply one uniform, but if they mess it up or whatever, they have to buy the next one. Okay. Or like if they have tools and the tools are going to, like if they lose the tools, then they have to replace them, right? Like they have to pay to replace them. Or if they're traveling and there are charges that are incurred over and above the agreed upon rate for the hotel, like they got caught smoking pot in the hotel room, and so the hotel charged a $350 fee to clean the smell out of their room, or they got stuff from the mini bar or whatever, then you need a way to deduct that from their paycheck. You cannot just deduct it from their paycheck. You actually have to have written permission for that. So you want to have that proper form for doing so, where they acknowledge that they will have to pay for that and that you have the right to take it out of their paycheck. There's a lot of laws surrounding that. So if you end up doing something like that, make sure you consult an attorney, because you have to make sure that they at least earn the minimum wage. Like you can't take out so much that they are making $5 an hour, that type of stuff. So there's a lot of regulations around that. So you want to make sure you get it correct. Okay. The other thing is creating a legitimate expectation that the employee won't be fired without good cause. And I put this in here because a lot of people think that you can only prove things that are in writing, but that's not the case. And this was a case where there was a secretary or administrative assistant who had been doing really well. She was in her annual review, and the people that were doing the review for her were trying to pump up her ego. And they said, "You are doing great. Wow, you're really good. And you are managing a workload that I don't know how you manage it. I mean, that is a stressful workload and you are doing it great. So long as you continue to manage your workload effectively, you have a job here." Now, did they mean to guarantee her employment? And the only way that she could be fired was if she stopped managing her workload effectively? No, that's not what they were doing. They were pumping up her ego. But that's the way the judge took it, because she was able to prove that they had said that. And in Texas, it is legal to record a conversation so long as the one party to the conversation knows that it's being recorded. So if Joe and Sally are having a conversation and Joe records it without Sally's knowledge, that's legal. Now, if Joe and Sally are having a conversation and Susie comes up and records it without their knowledge and is not part of the conversation, she's standing off to the side, that's illegal, right? But it's totally legal to record that conversation. So if you have a disgruntled employee, you better bet he or she is probably recording something. It's amazing how easy it is to record things nowadays. You just, your iPhone can record it without anybody knowing that you've got that mic on. There are echo pins that you can use to record. So there's quite a bit that you can use. So just count on that. But what they had done was they had said basically this, and she got fired for something else. She got fired because she didn't like a new employee that had been brought in to affect change she didn't like the change. And so she wasn't getting along with her. They were bickering back and forth. She was being insubordinate to the woman. And so they fired her because the change agent was more valuable to the company than the administrative assistant, because they could get somebody else to do the administrative work. They couldn't get this basic knowledge or the knowledge base that the change agent had. And she sued and said, you couldn't, I was still managing my workload effectively. It didn't matter that I was bickering with the change agent. So you got to be careful what you say to people and make sure that, like I said, still an at-will employee. Okay. And you don't like have to do that in the review, like going, well, you're doing really great, but you're still an at-will employee and we can fire you at any time. No. It goes in your employee handbook, where you can say that there are no verbal statements that can destroy the at-will status. Like, you can actually put that in there, right? So, okay. Hiring practices. So we got to get people hired before we can fire them for cause, right? So the hiring practices are, the first thing is you cannot discriminate throughout the entire process, from advertising to opening to hiring to interviewing to all of that. And you have to ensure that the job requirements are truly necessary for the job. Like, if you're hiring a janitor, you cannot require a college degree, because that's not required. Like, it's not necessary. They don't teach you how to be a janitor at college, right? That's not what they teach. And so a college degree does no good for a janitor. So if you have a job requirement that is not necessary to the job, then it can be seen as a way to discriminate against a group of people, whether it be an ethnicity or a religion or whatever. So you've got to make sure they're necessary. You have to apply the selection criteria evenly. Like, if you say you have to be able to, like, if you're a single parent, right? You can't just say no single moms. But if you're a single parent and you have parenting responsibilities most of the time, and you're like, the job that you're offering to these people it requires them to be on call and be at the job within 20 minutes of a call. Anybody ever tried to get a babysitter in 20 minutes without advance notice? It's kind of impossible, isn't it? So if you're going to say no single moms for this job, you also have to say no single dads. But what's better is to put the requirement out there, which is the job requires that when you're on call, and you will be on call 3 nights out of 7 during the week. So when you're on call, you have to be able to get to the office within 20 minutes, right? So that also means they can't live more than 20 minutes from the office. Okay. So those are, and you can't make exceptions. Oh, well, it's okay that you're 40 minutes away. We'll just make sure somebody else does that is 20 minutes away, right? You can't do that. If they're in that job, those job requirements are truly necessary for the job, and they're applied evenly. Okay. And I recommend, now this is not a legal requirement, but I highly recommend, depending upon the level of employee that you're hiring, but I recommend it for all, that you have them complete the application on site. The reason why I do that, and any testing that they're going to be doing, like, I have clients that have basic level testing. Can you give the correct change? Can you add fractions? Can you add, 0.25 plus 0.8, that type of stuff. And so they'll give those basic tests, but you want to do that on site, because what I have found is, no matter what level it's at, if you allow them to fill out the application on the internet or whatever, they may have someone else do it for them. One of my clients did actually have that happen, where he was hiring an administrative assistant. He took a lot of time interviewing people. He narrowed it down to 3 people. He and his wife then took the administrative assistant out to dinner and they had, the candidates out to dinner. They had another interview that way with her, with them, all three of them, not together, but just separately, 3 different dinners. So that's quite a bit of investment in the interview process. But she was going to be administrative assistant at work, but handling a lot of his personal emails as well, just because they get intermingled. And so he really needed to make sure that everything meshed. He selected his first candidate and gave her hired a background check company, did all of that, and then gave a skills test to her because he needed her to know Word, Excel, and PowerPoint fluently. So he hired her because she did stellar. I mean, she just did great and clearly could type well, could do all of that, everything. So he hired her. And on the first day, he gave her an assignment that morning, which was to change the file name of a file, like literally change the name of a file from one thing to another. And it took her 4 hours. She actually went to lunch not having that done. Yeah, that's the jaw drop, right? Like that's the real, doesn't everybody know how to change a file name? But no. And well, how did she pass all of her tests? Well, she had her daughter do them. And in her mind, she could learn on the job, that it would be so easy to learn. She hadn't learned it, and I don't know, she was a little older, maybe like in her 60s or something. So she hadn't learned it in her 60 years of living, and hadn't bothered to learn it since, computers came into our homes in the 80s. But she was all of a sudden going to be able to learn her computer skills on the job. So my client he just paid her for the day as an independent contractor and let her go. And she knew she had screwed up, and he was upset. But by the time this all occurred, he went to the second person and said, okay, I screwed up. I would really like to hire you. Well, the other person already had a job. And so then he had to start the process over again because the third person he had figured out wouldn't work. So he had to start the process over again. And that's a lot of time that he had already invested. So you can really save yourself a lot of money by doing the background check. And then if you have skills testing that you need to do, and having them complete the application on site. I have one client that has all of his applications done on site. He has a business that's really high turnover because they work out in the 100-degree heat. And so in the summertime, they last about 3 months as an employee. They just can't take the heat sometimes. Anyway, but if he doesn't have them fill out the application on site, he gets a lot of people that apply that can't actually, they're like illiterate. They can't read or write, or they're dyslexic, so that they read it wrong. And yes, that's a disability and he can accommodate that, but he needs to know that, right? He needs to know that that's a problem. And you don't want to hire somebody who's going to be your shipping clerk if they can't read the shipping orders or the purchase orders, right? And know how to fill everything out and slap the correct one and get that on. I had a client that, didn't follow my advice. They had like their brother fill out the application for them. They hired him as a shipping clerk, and he started like shipping, like they get clients calling up, you just shipped me something I didn't order. And he was pulling up and doing it so quickly and couldn't actually read. So he couldn't tell whether he was sending it to the right client. Yeah. So it was very costly for that client as well. So that's why I'm saying have them fill out the application online or on site. Have them in your presence. If they're doing any skills testing, even if it's available on the internet to do the skills testing, have them come into your office and sit there while you watch them do it, or have somebody else sit there and watch them do it, or put them in a room where it's just them, so that they're not getting help, right? Don't allow their cell phones to be in with them, that type of stuff. Okay, now there's one area where you're able to discriminate against employees, and that is if it's a bona fide occupational qualification. And some businesses have that. So it's kind of rare, but you know, there are bona fide occupational qualifications. So for example, I'm pretty sure that if I went down and applied at the African American Museum to be a tour guide, I would be looked at like, what? Like, there's no way. A bona fide occupational qualification for the African American Museum in Dallas would be that I be African American, because there's no way that I could actually be a tour guide and really give them that experience, right? Same like if I hated Dr. Pepper, I would not be a Dr. Pepper museum guide, right? Same thing. If you are working at a church, let's say at the Baptist church, you probably would not apply or be accepted if you were Jewish. So there they could discriminate based on religion, because they have it in, and it's a bona fide occupational qualification that you be Baptist in order to work at the Baptist church, right? So same with like Chinese restaurants or Mexican restaurants or whatever, although it's kind of getting to be a little bit more, I mean, like, you know, when you go into a sushi restaurant, you look and the sushi chefs are all Hispanic nowadays. They're actually doing better than a lot of my Japanese sushi chefs I used to love. So go figure. But but those are like, you know, it used to be, and probably still is, they could say it's a bona fide occupational qualification that you be Japanese if you're going to work at a sushi restaurant. That is so hard to say. Say it 3 times real fast. Anyway, same with a Chinese restaurant. You like, you know, if somebody who has red hair and dances a jig, an Irish jig, is serving you, do you really think that food is authentic? No, probably not authentic. So you want to make sure that, you know, if you have that type of a business, that you really do have a bona fide occupational qualification. So, okay. Oh, wait, sorry. Okay, background checks. You can conduct a background check on somebody before you hire them, and I highly recommend it if they are going to be using or working with cash or anything like that. You may want to do a credit check, because bad credit score often signals that they may be a risk for embezzlement. But I recommend that whether you do background checks, credit checks, or drug testing, it all be done through a third party. Now, if you're wondering who to do that with, just email me. I have a referral list that I provide as a courtesy to my clients, because they're always asking me, who would you use? Who would you use? So I have a referral list, and I do have background check companies on there that you can use. And some of them do skills testing and credit checks as well. So you can do those. And, you know, people think, oh, it's going to be so expensive. You know, it really isn't. The skills testing could get up there depending upon what level of skill you need. But the background checks and everything, those are, you know, $30-40 max, depending upon how extensive you want it to be. And that would include the credit check as well. Now, for skills testing, you can actually do your own skills testing. That doesn't need to be done by a background check company or by a third party. You know, I have a client who he has people who first screen everybody, and then he gets on and he starts talking tech to them, because it's a tech company. And he can tell within 2 minutes of talking tech whether the person has a clue what they're talking about and whether they're qualified or not. And so, you know, he doesn't waste time. He just immediately does that and knows whether they're qualified or not. If they're not, he just ends the conversation and says, well, I think you need to go get more training. And when you do, we'll be happy to interview you again. And that's it. But if he had a third party do it, they wouldn't have that same knowledge that he has. So now, it used to be that you could across the board say, if you have a felony, we don't hire felons. But that is no longer the case, because it has a disparate impact on certain aspects of society. So instead, you need to, if you're doing a background check and it comes back that they have a criminal background, then you need to investigate further and evaluate each individual case if something is found. So for example, if they have a DUI on their, but you investigate and it's 10 years ago and they've been to AA since, and they've been sober for 9.5 years or 10 years since it happened, and they've really turned their life around, well then clearly you could still hire them. If, however, it's a bank robbery and they're wanting to be your comptroller, well, that's a little different, right? That you can't have them being your bookkeeper or comptroller, for an armed robbery or something like that. If you're hiring a bouncer and it comes back that they had a minor in possession when they were 18, who cares? Or if they, whatever, but if it comes back that they had an assault and battery, you cannot hire them. So do you see how you put, you have to look at the job and what's required, and everything. And if you have drivers, etc., you may want to periodically just do background checks on people, because you'd be amazed at how many times you don't know what's going on. And somebody spent the weekend in jail and you had no idea and they have not told you, and it's something serious that would get them fired. Or you've got people who drive for you. Your insurance company will likely require that you check at least their licenses every 6 months, and your insurance company will likely do that. So you'll have to provide a list of your drivers to the insurance company, and they'll run the check on the license every 6 months, and they'll let you know if you need to stop somebody from driving your trucks or whatever, because they got a DUI or they got a speeding ticket that was way too much, or they got into another wreck that you didn't know about. So it's always good to run those periodically. Now, this is something that's just new, and it just came out recently. The Texas Department of Insurance has revised their policies with regard to doing searches on potential employees for their workers' compensation claims. Previously, it would cost you $2 a search, and they weren't really fond of it. They didn't like you to do it. Now you can use DWC Form 156. There's a link on my Facebook page. So on my Travel and Law Facebook page, I have an article about this, and there's a link to the DWC forms, but you can also just Google Texas Department of Insurance Form 156 and it'll come up, and you can use that to then investigate. It no longer costs you any money, and it's a good thing, because especially if you are in like a manufacturing industry or an industry where there's a high risk of injury, you can find out if the person is accident prone, has made a lot of workers' comp claims, because if they've made a lot of workers' comp claims, they're going to increase your workers' comp rate quite significantly. And you can take that into account in hiring the person. So that's kind of a neat tool that's just come available. So I love that. All right, so undocumented workers. The rule is that you cannot employ undocumented workers. In order to employ them, you have to verify that they're an American citizen, that they have a valid green card or an applicable visa. Getting the social security number is not enough anymore. You have to go to E-Verify and put it in and see what happens. Now, if you don't do E-Verify, that's okay. But eventually you're going to get a no match letter from the Department of Homeland Security. And what that is they're going to say, hey, you said Jane Smith of this social security number works for you, but we don't have a Jane Smith with that social security number. It doesn't match, right? The name and the address of the person doesn't match. And or they'll say, that's to somebody else. They'll never tell you who, but they will say it's to somebody else. At that point, that's when you have to respond and say, "Ooh, okay, well, I think it was a typo. So sorry, try this number," or whatever. Or you go, "Oh, you're absolutely right, but they no longer work here." Because if they are undocumented, most likely they're flitting from job to job and they're not working there long enough, because it takes DHS. Let's see, one of my clients had this happen to them. I think it was a full year before the DHS sent them the no match letter. And that employee had been gone for, I don't know, 10 months already. I have other clients that they don't employ them. They just do independent contractors, and they know that it's a risk, and they pay them cash at the end of every day. And that's a risk. It's also a risk because you can't deduct that cash. Like you're going to end up paying taxes on that cash, because you can't very well say, "Well, gee, I paid people under the table." They end up claiming that it's to something else. Like they paid a marketing firm, or they paid something to get it off their books. But it's unethical to do that. It's not, it's against the law, but it is done. People ask me all the time, "How do they do that?" Well, I figured that out because I finally had some clients that were doing it. So anyway, now with this administration, they don't seem to be enforcing it as much. I don't see it as enforced as often, but it had been enforced probably for the last 20 years very strictly for this E-Verify. So totally up to y'all. Okay, so now let's get into firing practices. So long as your employee is at will, you can fire them at any time for any reason, as long as it's a legal reason. Here's the deal. You will save a lot of money and heartache if you just call your attorney and have a 15 to 20-minute conversation before you fire somebody, because they can walk you through the process and make sure that you've done it in a way that will save you money, or in a way that will keep you from getting fired. Okay, so it is best to fire someone for cause. So what would cause be? Well, it can be poor work performance. It can be, and this is not an exhaustive list by far, harassing or discriminating against other workers, refusing to follow instructions, cussing out your boss, that you can be fired for cause for that. Basically violating any company policy with and everything. If it's more egregious, you're going to need, you don't need as much warning. If it's not as egregious, like, oh, they were absent, or they were late to work, well, you need to give them warnings. You can't just fire them the first time they're late to work, even if it is in your employee manual or employee handbook that they can't be late to work. You've got to follow a different, and I'll talk to you about how to do that in a little bit. If they're abusing sick leave, or they have excessive absences, notice I say absences, not just one, or if they're tardy, and it's excessive tardiness. If they have drug use or criminal activity on your work site, then yes. But if they're using drugs outside of work, that's not your issue. Criminal activity can be your issue, right? That you can fire people for that. Disclosing company trade secrets to third parties, that would get you fired immediately. Using alcohol or drugs at work, that is going to get you fired immediately. But here's the deal. You can't fire somebody for being a drug addict or an alcoholic. That is considered a disability, and it is covered by the ADA. So you can't just be like, "You're an alcoholic, get out of here." But you can fire them because they're coming in late, they're missing work, they came to work drunk, clearly, that type of stuff. And by the way, if they come to work drunk, don't make them go home in their vehicle. Call them an Uber, right? Call them a taxi, and then, or have somebody else drive them home. Like have somebody drive their car home and yours. You'll be liable if you know that you're sending out somebody that is drunk in a car, right? So But anyway, so there's always going to be a way to fire them if they're an alcoholic. I have some clients that have chosen, instead of that doing the alcoholism, they've and firing them, they send them to rehab instead. They turned a good employee, or a crappy employee who had a disease, into a very good employee by helping them get sober. So, there's different ways to handle it. Okay. Now, how do you fire? Because you've got to have the correct practice, and you want to make sure you do this right. So the first thing is you have to document the issues. So, you review your handbook, and that's not in here, but review the handbook and see what policies they're breaking, because you need to know that. And then you need to have a write-up that says, this person is getting a verbal warning, they're getting a written warning, they're getting a whatever. So you want to record what it was. And then what area of the handbook or what policy of the company are they violating? And then you want to meet with the employee and tell them what they're doing wrong and how they can fix it, right? So what are you doing wrong? What do we expect you to do in order to fix the problem? Then inform them that if they continue down the path that they're doing or continue to do it wrong, it could be a terminable offense, right? Record the meeting in writing and have the employee sign it. Now, if the employee doesn't want to sign it, you just write employee refused to sign and the date. I don't really care whether they sign it or not. What I care is, do you have a systematic recording or a systematic process? Like if you are just doing a verbal warning, that's totally fine, right? But you need to have a process where you go over to like your calendar, like a wall calendar, they still do have those, and write on it. Like, I have some clients that take, those free calendars from like World Wildlife Fund, and they have them in their desk drawer. And they get that out of their desk drawer and they write on the day, spoke with Randy about this, told him this, and it's on that day, so that they know that they reprimanded the employee at that time and it was a verbal. And you just say verbal, boom, done. Because what I care about is it systematic, right? Or is it just hodgepodge? You need to be consistent. It needs to be systematic. So you have to have some sort of a system. So if you're giving verbal warnings, you want to just like literally just write down, I gave them a verbal warning, and put it in their file or put it on that calendar or whatever you need to do to make sure that there's a system. Okay. Now, the magic number of offenses is 3, but it could be less depending upon the severity. Like I said, it's really, you've got to weigh it. If they're disclosing company trade secrets, they're out of there the first time, right? If they're lying to you, you can't fix dishonesty, right? So they're out. Especially if it's a pretty big lie, usually they're out, right? Because it's hard to fix dishonesty. You can fix an alcoholic, you can fix, poor work performance, because maybe they just didn't understand what they were required to do. Maybe it wasn't communicated well, etc. So those are things you try and fix, right? Some things you can't fix. Like if they're sexually harassing somebody or discriminating against somebody, you may end up firing them, but you may actually end up just talking to them and saying, this is inappropriate, and giving them training on why it's inappropriate. And you can turn bad employees into good employees sometimes. So it really just depends. It's a long list of things that you can do. You can give them verbal warnings. You can, withhold their bonuses. You can demote them. There's a lot of different things that you could do. Okay. Now, I kind of put this in here. So just kind of as an aside, because people go, well, once we get them fired, what do we do? When potential employers call for a reference. I used to, and most of my clients have this policy. We confirm the dates of employment. We state it's your policy not to rehire, and we don't provide information on the employee's performance, right? That's been like the advice for so long. But Texas now has a policy that says that you can, and the reason why that is because you could be like, if you gave an opinion and they didn't get hired, they could sue you for defamation, right? So you just don't want to invite that lawsuit. So you just give that. But Texas now has a statute that says, so long as it's your opinion, or if it's fact, you can back it up and prove the facts, then they can't, it's not defamation. You won't be held liable for it. So, and I'm so glad they've done that, because there are times when you just want to be like, oh my God, don't hire them. They embezzled $100,000 from me. Please don't hire them. They're going to just do it to you, right? Like, you want to tell them, you want to save the person from experiencing what you experienced. So as long as you have proof and you can back that up, you can tell them, don't hire him. Or, yeah, I'd probably hire him, but I think that, he probably needs to work on this skill the most. So if that's a skill that you value, then you may want to help him with that, right? Something like that. You can totally do that. Okay. Now, medical marijuana. I go all over the place nowadays. Like, this used to be an hour-long class, and I've added a lot of stuff. Anyway, medical marijuana is becoming more and more of an issue in the workforce, especially if you have projects outside of Texas. In Texas, medical marijuana is still illegal. Marijuana is still illegal. So you can say, nope, you cannot do drugs at all, right? Like, that's it. You just can't do it. But in other states, all but 3 states have some form of medical marijuana use. It's just that in Texas, it's non-euphoric oils. So they're not going to come to work high. But like, if you have a project up in Colorado, you might have employees come into work high because they can recreationally use marijuana. And so you have to look at, well, is that a requirement for the job that they not be high? So for example, if you're a manufacturing business or you're a construction business, yeah, it's kind of a job requirement that they not be high on the job, because if they're impaired and they're working a forklift, that's pretty damn dangerous, right? It's pretty dangerous. But if they're a programmer and they happen to write their best code when they're really high, and they're working from home, like a lot of programmers do, it's not such a big deal for them to be high and working in Colorado or whatever. So it's really what works for your company. And you need to have it very clearly stated in your employee handbook. You see why one size fits all employee handbooks don't work. That's why I don't like all the HR companies coming in and saying, here, we'll give you all this stuff. And you're like totally confused and you don't know how to change it. So you really need somebody that's going to do it according to what you need in your business. Okay. So you need to keep up with the medical marijuana and recreational marijuana laws. Right now, federal law still prohibits marijuana use, although they're banned from raiding in those states where it's legal. So I've given you a link of where you can keep up with it because you want to. But the most important thing is, can you fire an employee for using medical marijuana? And in most states, yes, you can. There are some states that require limited circumstances. You may have to accommodate somebody that needs to use medical marijuana at work. And you may have to just allow use during hours they're not working, which really doesn't work, because they can, use it as they're driving to work. And in a lot of instances, marijuana can still impair you for up to 24 hours afterwards, depending upon whether they're doing edibles, etc. Yeah, I've done the research. Had to. So anyway, so it, sometimes it's just 1 or 2 hours, but they're still coming to work high. So it can be problematic. So if you need a policy that if they cannot be impaired, then they cannot come to work impaired, like, right? They have to have done it long enough away from the time that they come into work that they are no longer impaired. Okay. Now, there are obviously exceptions, which are safety sensitive positions and jobs that are regulated by federal programs that require drug testing and all. So, right. Now, if you're going to do drug testing, you need to use a third-party drug testing company, because there are a lot of different laws for what you need to do. It used to be that you could automatically, if there was an accident at work, you could automatically require a drug test. That is not the case anymore. They've decided that's discriminatory. I don't quite understand it, but you need to put into place some sort of policy if your workforce is one that's an area that's prone to accidents, or that it has high risk for accidents, like using forklifts. Like a company like Costco, where they've got all these things stored way high up, you want to make sure that your employees are not impaired. Now, Texas does not have a statute restricting drug testing by its employers, so you can do that, but you need to have a policy for it. Like, we drug test in order for you to get a job. Your job is contingent upon you passing a drug test. And believe it or not, we've hired people and said, okay, you're gonna have to pass a drug test on Monday, and they call on Friday and go, yeah, well, I won't pass it, so I'm not even going to come in, So anyway, and then you can have a policy about doing random drug testing, because you do need, like, if you have a policy for random drug testing, you actually need to do random drug testing, right? Because otherwise you're not following your own policy. And random drug testing could be just picking one employee every month to you're up, just make sure it's not on the third Wednesday of every month, right? Like, people will know, oh, today's the day, we could be the lottery, so you want to make sure it's truly random. Now, some people have tried to make claims that medical marijuana use, it falls under the ADA, but the ADA does not protect illegal drug use. It is still illegal federally, so it won't fall under the ADA. Everybody that had, all the courts that have considered it have said, nope, it does not require employers to accommodate medical marijuana use by employees. Just so you understand, the ADA, if there's a disability, you have to make reasonable accommodations under the law for whatever their disability is. And so people are trying to say, well, my disability is I need medical marijuana. That's the treatment. That's the reasonable accommodation. And it's not flying in court. So, but it is being challenged in the courts. So you need to check back often. So definitely, check that and keep up with it. And especially if it's happening in Texas, you really need to pay attention to that. And if things are coming up, I inform people on my Facebook page. So feel free to follow that. I don't post that often, but when there's a change in the law or there's something that y'all need to know, I post. So, okay, now let's talk about unemployment insurance, because that's a big cost for employers. So who is eligible for unemployment compensation? Any employee that is terminated for cause or voluntarily quits, and there's an asterisk with that, and I'll explain why in a minute, cannot get unemployment compensation. It's only when you terminate them without cause that they can successfully file for unemployment insurance against you. So why does that matter? Well, because it increases your costs. And let me tell you how much it increases your costs, okay? So right now, the lowest unemployment insurance rate is 0.31%. So, and that is on the first $9,000 of your employees' pay. So if you're a high turnover company, you're constantly paying that. If you have employees that have been with you 20 years, or they stay for a while, then you will just pay it on their first 9,000, and by the end of the year you don't have anything accruing or accumulating to pay. So it really depends. But if you're at the lowest rate, that 0.31%, you're paying I think it's $27.60 on that. That's it. Per employee, that's what you pay. If, however, you are at the highest rate, which is 6.31%, which is quite a bit, you are now going to be paying I think it's $576 and change per employee. Do you see how expensive it can be if they successfully file unemployment insurance on you? Right? So if you have a lot of claimants, if you have a lot of employees that you are terminating without cause and they are successfully getting unemployment insurance or compensation that is tagged to you because they have to, they say, oh, you're the cause of that, you fired them without cause, then your unemployment insurance rate starts to go up. Now, when you first form your business, it's going to be the middle of the road, and it'll go up or down depending upon that. After 3 years, if you don't have any claims, it's going to go down to the lowest amount. That amount varies every year. So when I'm saying the numbers, don't quote me next year, because next year it may be 0.39%. I've had it as high as 0.51%. So it just really depends. And the Texas Workers Commission, TWC, they're the ones that set the rate. Okay, so that's why it matters, because it can be very costly for you if you get this wrong. That's why I go over how to fire for cause so much. And I spend a lot of time on it because it's very important. So this is the problem of doing Zooms at home. I have cats that get in the picture. So this is Buster. Everybody say hi, Buster. Okay, so what to do if an employee files? Like if an employee files for unemployment, you've terminated them for cause and they file for unemployment, like they have the gall to do that, right? They do it all the time. I mean, I just terminated somebody for cause recently for a very egregious matter. This was not my firm. This was for a client. And they called me up and said he filed for unemployment and told them that he was laid off due to COVID. That was not anywhere close as to why he was fired. But, you know, they're going to file if they can. They don't understand the system. They don't understand. Even if they quit, they'll file because they don't get that they can't, right? That they won't be able to get it. And they think, well, maybe I'll get away with it. And there are clients that say, you know what? I don't have time to respond. I don't care if I'm at the highest rate. It's fine. And they're okay with employees filing for unemployment insurance, whether they deserve it or not. Right. So, and that's what the employee is hoping for. So the number one reason why an employee successfully files for unemployment compensation is that the employer does not respond on time. Lack of timely response is the number one reason. So make sure you respond on time. The letters specifically state when you have to respond. Now, employees who voluntarily quit, they are not able to collect unemployment. However, if they quit for good reason, then they can collect unemployment. And good reason is something that's connected with the work that makes it to where it was so bad they had to quit, like unsafe working conditions. A lot of people have tried to get COVID as an unsafe working condition. It's not working. That's not flying. So that, you know, you're safe there. You know, if you decide you're not going to require masks at work, or if you do decide you're going to require masks, I mean, I get the arguments either way. Like I get employees saying, oh my God, they've got to wear masks. I'm just not even safe. And then I get other ones going, I can't even breathe in a mask. It's unsafe working conditions. So you're going to get both. And just know it's not a reason for them to quit. If they want to quit, they can, but they won't be able to collect unemployment insurance. So unsafe working conditions, significant changes in the hiring agreement. You agreed that they would get a 5% commission and you've reduced it to 1%, right? Something like that. Or not getting paid, or difficulty getting your agreed upon pay, that would be a reason to quit as well. So, and if you're not getting, you know, if they're not getting paid, they're going to report it to the TWC no matter what, because they want to get paid. So good reasons that are not related to work, because it doesn't always have to be related to work for them to have a good reason to quit, is if they had a medical illness or an injury prevented them. So they were in a huge car wreck and they broke their ankle and they broke their sternum and ribs and they can't work for 4 months. And you say, well, if I got to replace you, and they quit, right? Or if they're pregnant and you are, making them work through a difficult pregnancy where the doctor has said bed rest, etc. And, they can quit, say, my doctor said I have to have bed rest. That is good reason to quit. I know you didn't have anything to do with it, but that will do it. Same with if your child has a terminal illness or a medical illness or a terminally ill spouse. If they've been sexually assaulted and they need time to get over that, they can quit for that, family violence, etc. So you can see that there are quite a few reasons that they can quit that are not related to work, and they're still going to be able to claim unemployment against you. And those are just ones that you just kind of have to take it on the chin and go, okay, better luck next time. I feel for the person, and, they deserve the unemployment at that point. And you just, yeah, that works. Okay. Back to unemployment claims and how that works. So if somebody makes a claim that's an employee, first of all, you need to realize that the law is in favor of the employee. It actually states on the TWC website, our employees are employees, so they actually lean more towards the employee. They do. They favor the employee. So whoever the investigator is, they're an employee, so they kind of have a heart for the employee versus the big bad, company that's hiring them. So the standard is, would a reasonable employee expect to be fired for the reason in question? So, if somebody's goofing off at work and, you're not reprimanding that person for goofing off at work, so then somebody else goofs off at work and you fire them, that's not a reasonable expectation that they would be fired, because you've created a pattern of goofing off at work, and that's, yeah, right. So you can't just all of a sudden go, I'm going to fire this person, but not this person. Okay. So that's why the warning system that I told about, where you write them up, you do verbal warnings, those things, those are so important, because that sets up and proves to the TWC that they had a reasonable expectation that if they continued to do that, they would be fired, right? So that's why you discuss the problem with the employee several times before terminating them. But like I said, there are some things that are so egregious, you terminate them immediately, right? And that's a reasonable employee would be expected to be fired for something like that. Now, do not take action in anger at all. A lot of times people are so pissed off at what the employee did that they're just like, you're fired, you're out of there. Take a step back and call your attorney. That 15 to 20-minute conversation is going to save you money in the long run, I guarantee you, because they're going to calm you down. They're going to ask you facts. They're going to go and analyze it and determine whether or not you can fire that person for cause or not, or what you need to do in order to fire the person. Okay. Now, when you fire the person, you have to provide the reason for the termination to the employee. Follow your company procedures. Don't just fire somebody and go, you shouldn't have been doing this. And then you go back and look at your company procedures and you realize that wasn't even against your company procedures or policies. That's why it's important to call your attorney, because they're going to go back and look at your employee handbook, and they're going to see whether or not that's a policy that they're violating in the first place and what they are. And I guarantee you, a lot of times, like my clients, you'll call up your attorney and you'll say, well, I need to fire Joe, or I need to fire Sally because of X, and they're doing this. And then you start talking and they go, oh, okay, they're not just violating this, they're violating these other 4 company policies, right? And so they're going to issue spot for you things that you can fire them for, and increase the amount of cause to fire that person. Almost every time somebody calls me and talks to me about needing to fire somebody, I can find for them multiple other infractions. So, okay. Investigate the complaints from an employee. So like if you're firing somebody, or an employee just comes up to you and they complain about somebody else, you need to investigate that. anytime. And I have a procedure for that set out at the end of this that we'll talk about. Address problems as they occur and do not let them slide. I had a client that called me up one day, and they were upset because they had they were in a business where it was a lot of risk for injury, and they had somebody who was goofing off, and this was the third time that this person had gotten injured on the job because they were goofing off. And we had two problems. One, she had never met with him to tell him that that was unacceptable and that he could not goof off at work and that he could be terminated for it. So she had not set that up. But what was worse, because she hadn't done that, she had actually created a work atmosphere where it was okay to goof off. And then the biggest problem that she had was if she needed to fire for cause at that time. And but she couldn't, because she had created a work environment where it was okay to goof off. And the problem was, if he goofed off again, he might not just get a small little injury. He might actually die or lose a limb, because it was that risky of a job atmosphere. I mean, they had heavy equipment that could come off the shelf at any time, or, that could cut them, etc. So that was a problem. She had let it slide. She's like, I was too busy. So it doesn't mean that she couldn't fire him. She could terminate him at any time for any reason, but she knew she was going to be in trouble with the unemployment claims, and it was going to put her in a higher bracket than what she really wanted to be able to afford. And so she wanted to make sure that she could fire for cause. Well, because she called an attorney, we thought outside of the box. And so my advice at that time was, okay, so tomorrow when this guy comes in to work, you're going to pull him in and you're going to say, I'm very concerned that you were injured, and this is the third time. And I think that you've been goofing off, and that's not allowed. So we set that right there. You cannot goof off anymore. So we nipped that in the bud. And then I had her to say, well, and also, I really think that maybe we need to train you better, that maybe your training is lacking in how to use the tools properly and what to do in safety protocol, etc. So I'm going to follow you around for the next 2 weeks and train you. And my client went ballistic. She's like, oh my God, I barely even have time to reprimand him. I don't have time to follow him around, blah, blah, blah. I mean, she just went crazy. I said, well, we've got to take care of this. So you need to put in the time. But I don't think you'll be following him around for 2 weeks. But if he stays and returns the next day, which I seriously doubt he will, but if he does, then you can turn his training over to Jack. And Jack was, a manager that could help with the training. And Jack can then put him with somebody else who does his training the next day, so that you can have different people training him. You don't have to follow him around for 2 weeks. So she did that. The next morning, she had that discussion with him. She followed him around all morning long, teaching him stuff. She would teach him how to do it, what the safety protocol was. She would say, do this for 30 minutes. I'm going to go take a phone call. I'll come back and see how you're doing, that stuff. So she did work out a way that she didn't have to follow him around all morning long. He didn't return. He went off to lunch and never even came back, never called, never told them. He was just and the reason why is because he didn't want to work. He wanted to goof off. Now, was that legal to do? Absolutely. Because they had every interest in making sure that he was trained properly. Did I think he would quit? Absolutely. I knew that. And that was fine. So, but then if he had taken to the training and decided, wow, this, I could learn something, he could have been turned into a really good employee. So absolutely, it's allowed, because there have been times when we've used that exact protocol and taken a crappy employee who was just goofing off and basically said, you're better than that. We're going to train you to make sure you are better than that. And they rose to the occasion and became a really good employee. So, you know, you really have to weigh it, but that did exactly what we needed to. But that moral of that is, don't let it slide. If they're goofing off, if there's a problem, you need to address it as soon as possible, because if you don't, it creates an environment where that's okay at work. And then if you enforce it with one but not the other, then you have people really upset because you're not treating employees equally, and you have to. So, okay. Now, the burden of proof is on the employer to prove misconduct. You have to be consistent with your cause for firing. You know, don't change your story. It's got to be consistent the whole time. Eyewitness testimony is obviously the best. So if there's a manager or a worker or a colleague that can testify, that's going to be great. Because if they get, like, if they file for unemployment and they actually get it, then you can appeal that, right? So this is like in the appeal or whatever to prove it, and all. Or if they don't get it, they can appeal that, and then you're stuck trying to prove it as well. So you want to make sure you have documentation that proves the rule or policy, that you have all that evidence gathered, and that you have it sound and reasoned out. So that's why it's important to contact your attorney before firing an employee when you receive the claim. Don't try and answer it on your own. And the biggest piece of advice that I can give you, if you don't learn anything else about this unemployment claim stuff, is don't ever, 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 don't you do it. Don't respond online, ever. Don't do it. It's tempting because we're all we're the online people, right? Like, that's our generation. Everybody does everything online. So why wouldn't I do that? I mean, oh my God, you mean I have to fax it in, or even worse, US mail? Oh, yep, absolutely you do. And the reason is, in fact, I just filed a response to, or a notice of appeal today. If I had tried to respond online, I think I was limited to 1,000 characters. I filed a response that had, I think, 26 pages of proof of why the person was fired for cause. I could never do it justice in 1,000 words. And I can tell you that every client that has ever filed online loses that. And a lot of times they haven't said enough in that I can then expand it in the appeal, right? So you want to make sure that if you are responding to a claim and saying, no, they're not right, you want to make sure that you do it right, and you do it not online. You do it via fax. You can do it via fax, or you can mail it in. Those are your best options. Do not do it online. Okay. Okay, workers' comp. It is not required in Texas. What workers' comp does is, if somebody gets injured on the job, it limits the amount and type of compensation for an injury so that the employee can receive. So for example, if they are, and it doesn't look at fault, right? It doesn't look at fault, like the employee's at fault, or the, who was negligent or whatever. But let's say an employee loses their arm because they didn't have the guard up or whatever on the saw. Well, then the workers' comp system has said, we will pay out the medical bills for this, and like, I don't know, $125,000 or $150,000 in pain and suffering. And it limits what they can get from the insurance company on this. Okay. Now, best practices are that you have to have a coverage or non-coverage poster on site and notify new hires of whether or not you have workers' comp insurance or not. So you've got to inform the employees of whether you have it or not. You cannot retaliate or prohibit claims. That is a big no-no, and that will get you sued big time. If you say, don't put this through workers' comp, we'll cover it elsewhere. They have the right to do it, and they can. Avoid the benefit stacking. So for example, if like they are they've got workers' comp because they got injured on the job, and that, like, let's say they fell off of a forklift and injured their back. So back injuries typically have you out for a while. So they have short-term or long-term disability payments as well that they're getting. You want to make sure that whatever they're getting from workers' comp from Texas unemployment, if they're getting that, or from the short-term or long-term disability, that they are not making more than they would make if they were working for you. So you got to make sure of that. If it's more, then that can be problematic. So the biggest thing and advice of practical nature I can give you is don't allow your employees back to work until they're able to work without restrictions. I see this a lot where the doctors will release the employee and say, oh, well, they can come back to work, but they can only walk 1/4 of a mile a day. Or, oh, they can't stand up for more than 10 minutes an hour. Or, they'll put some sort of a restriction on it. That is bad news for you, because if they come back to work, even if they voluntarily don't follow the doctor's orders, like they have to walk to the printer, and it means that they are probably walking 1/2 a mile a day, or they have to stand at some function to operate some machine, and it's 30 minutes an hour or whatever, and they voluntarily do that. If they re-injure themselves, it is no longer covered by workers' comp. Now, if they come back to work and it's a different injury, then it's covered by workers' comp. But if it is a similar injury or caused by the first injury and caused by them not following the rules, etc., no matter what it is, it's not covered by workers' comp. And then you as the employer are liable for it personally, or not personally, but the company is liable for it. So you want to make sure that they have a doctor's note that says 100% without any restrictions, they can come back to work. If you don't have that, you just look at them and say, until I have that note from your doctor, I can't let you back. So, okay. Wait, yeah, there we go. Okay, so workers' comp covers an injury or illness without regard to fault. It does apply to work-related travel, even if they're off duty. So like if it's after work, they're in Paris and they step off a curb and break their ankle as they're on their way to dinner or back from dinner, that's covered under workers' comp. But it has to be that they're furthering or carrying on the employer's business as well. So if they're like on work-related travel, they've been there for a week and then they take a week vacation, well, then it's not on workers' comp if they injure themselves in the second week in Paris or whatever. Now, let's say you have an administrative assistant that at the end of every day, on her way home from work, she goes by the bank and makes the deposit at the end of the day. So when is she considered off duty? Well, she's considered off duty when she's completed that task, not when she leaves work. So if she gets in a car wreck between the place of work and the bank, then that car wreck and any injuries that she receives is covered by workers' comp. If, however, as she's driving away from the bank after making the deposit and she turns out of the parking lot and gets in a wreck, that's not covered by workers' comp because she's no longer furthering or carrying on the employer's business. She's done with that. She's on her way home. Now, it doesn't cover injuries from horseplay. So that's why it was such a big deal with my client, is because they're goofing off. That's horseplay, right? So it wouldn't be covered under workers' comp if they got seriously injured. Willful criminal acts, self-injury, like, the old cutting off the finger trick that, you always see in Hollywood. Intoxication from drugs or alcohol. If they're intoxicated and they get in a wreck or something, it's not covered. If they're voluntarily participating in off-duty recreational activities. So if you have a company picnic and it's voluntary to come to the company picnic, then that's not covered. But if you require them to come to the company picnic and participate in the volleyball game, then it's covered. If it's a third-party criminal act, or if a person, for a personal reason, not work-related, like, like they were robbed or something like that, and it wasn't work-related. If they're robbed on the way to the bank to make the deposit, that's covered. Acts of God, like, when that tornado came through Dallas, that act of God was not covered under workers' comp. So if like that Home Depot where they had all those, like they let all the employees go and no one was injured, but if, let's say, he hadn't let them go and there were all these injuries, that would not be covered under workers' comp, and Home Depot would have been liable. So hopefully y'all know about that since it's Dallas. Okay, Affordable Care Act. If you offer health insurance, you have to meet the minimum standards of the Affordable Care Act. You have to provide employees with a summary of benefits and a coverage form, and the coverage must kick in within 90 days. Most kick in within 60 days now. You must provide new employees with a notice of marketplace coverage options as well. So not just a summary of your benefits and coverage, but the notice of marketplace coverage options. So they have to know they can either go to you or they can go elsewhere. It's up to them. Okay. All right. If you don't offer health insurance, you must offer it if you have 50 or more full-time or part-time, which is average of 30 hours or more. So like if you have two 30-hour or 29-hour employees, they can be combined to make one employee for calculation for this. Now, here's where it gets dodgy for a lot of my clients who are serial entrepreneurs. They have a lot of businesses. They don't just have one business. They've got 5 or 6. And so you need to be careful if you own more than one company, because common ownership can make it so that your companies are combined for ACA purposes. So you may have 5 companies with 10 employees each, thinking, I don't have to do ACA, but you do, because that makes you meet the threshold. I've had clients that have had to sell off some of their companies because like one had a landscaping company and a manufacturing company, and they offered healthcare to the manufacturing company, but they couldn't afford to do it for the landscaping company that makes $25 a yard for mowing. And so because of the ACA, he was going to have to start offering not just any type of insurance, but the same type of insurance, because he can't play favorites, and he has to treat all employees equal and offer the same exact insurance. And so he had to sell off the landscaping business so that he could maintain his manufacturing company with health insurance. So you've got to be careful of that and make sure that you're not just counting per company. If you have common ownership, you may have to combine that for ACA purposes, and you may end up having to offer health insurance to your employees. And then apparently I make sure that y'all know you have to provide the notice of marketplace coverage options. All right, now we'll get into the really good stuff. Independent contractor versus employee, and why do we care? Because I get a lot of people that say, oh no, I'm just going to hire independent contractors. And I'm like, ooh, have you done the analysis? Can you hire them as independent contractors? And why do we care? Well, in the handouts, there is a thing that goes over independent contractor, employee, and renter for a massage studio, right? Or a hair salon. It could apply to a hair salon as well. All of those are options for that type of a business. And it kind of goes over the differences. But you do care, and the reason why you care as to whether you get it right is because there's tax liability and overtime pay and benefits that you will owe if you get it wrong. So if you're categorizing people as independent contractors and they should be employees, and you get audited, you are going to pay them overtime pay a lot. So for example, if they're working for you 50 hours a week and you should have paid them as an employee, you would owe them 10 hours of overtime pay for 2 or 3, for up to 2 to 3 years back pay, right? At 10 hours a week, that can be quite the hit. Also, you're liable tax-wise. And if they find that, so it's 2 years if they don't find that you did it on purpose. But if they find that you did it on purpose, then they'll go back 3 years. So that can be quite the hit. I had a client that had this happen to them, and you get audited when you fire somebody and they're pissed and they start calling every agency they can to see if they can trigger an audit. And this one, the Department of Labor went, oh, we don't have anything better to do. We'll send somebody out there. And so they did. And this poor small business that is just struggling to make ends meet was doing it wrong. And they ended up paying $18,000 to their employees in back pay, which was quite the hit, because it's not like they go, well, you can pay that off over time to your employees. No, it's like you have to pay that within 30 days of them finishing the audit or something like that. It's crazy how quickly you have to do it. So it can be very problematic if this happens. So you want to do it right from the first place, because paying overtime, if you have to, is easier over a period of time than in all one lump sum. So now an independent contractor can turn into an employee after a period of time. Usually it's, a year and a half. That's why all the tech companies give independent contractors 18-month contracts. And then they say, go work somewhere else or take a vacation for a month, unpaid, of course. And then we'll hire you again for another 18 months. So, okay. I'm not going to go over all these tests. In the handouts that I gave you the link for, there's another test as well. That's actually the one you need to pay attention to, because that's TWC. And I will say right now, the TWC itself is being really hard on it. They are strictly enforcing it. And basically, if you have any say in a behavioral control over your employee or the person that's working for you, and when they have to work, what they have to do, how they have to do it, they are an employee. I actually went up against the TWC with one of my clients. They had independent contractors who loved being independent contractors, did not want to be employees, did not want to have a set schedule. They loved being able to pick the days they worked. And basically what it would be is my client would send out an email saying, okay, we have this many patients coming in for testing this day and this day and this day. So we need 5, 4, 2, 8, technicians, right? Pick your days and let me know when you're going to do it. And so that fit the classic definition of an independent contractor, because they would come in and they would do all the testing, etc. Except that if they chose a day to work, let's say they chose Tuesday, they didn't have control over the hours. They had to be there from 8 in the morning until 2 in the afternoon. They couldn't say, oh, I'm not going to come in until 11. Can you schedule them from like 11 to 4? No, it was, if you're going to work, it's 8 to 2, but you can choose whether you work or not. It's classic for being an independent contractor, except that the TWC says no, because you control the hours they work, the times, right? Then they are an employee. Just that one factor. And it used to be that it was a totality of the circumstances. You would weigh like, okay, these things over here point to employee and these things over here point to independent contractor. Which ones weigh the most, right? And then you decide. But that's not the way it is anymore. It is literally, is there an ounce of control over that person? Employee. And the reason why they're doing that is because they make more money. They do, they make more money. So anyway, so I'm not going to go over all of this. What I'm going to say is, if you have any type of control over the employee, whether it's how they perform the work, what tools they use, if you supply the tools and equipment, all of that, then that points to employee and they are an employee. So more often than not, they're going to be an employee. Independent contractors, more often than not, are going to be companies that you hire to do a project. And that is one of the bigger tests is, you hire an independent contractor for a project. You hire an employee to invest in time with them, and you want them to work for you forever. An independent contractor is, when they're done with the project, they're out of there and you stop paying them and they stop working for you, like building your website or whatever it is, right? So, okay, so I'm going to go past all of this. You now have all of that. You can read it, you understand all that. If you have any questions, feel free to email me, but I'm not going to waste time on this anymore because, like I said, that handout that I gave you from the TWC rules, that's the one to follow. Okay. Now, there are people who are statutory employees or statutory independent contractors. This is not an all-inclusive list. The IRS has a list and you need to check it because it changes occasionally. But it's impossible for me to put everything on here. So I just do the most common ones, which are workers who work from home according to the company's specifications on materials or goods supplied by the company. So if you supply them with a laptop, right, so that they can work from home, then they are going to be a statutory employee, right? Crazy, huh? Business to business salespeople, if they're selling merchandise for resale or supplies for use in the buyer's business, then they are, hold on, there we go. Then they are going to be an employee, a statutory employee. Now, non-employees are like companion sitters, direct sellers, licensed real estate agents. They are statutorily independent contractors no matter what. Doesn't matter how much control you exert over them. They are independent contractors. So obviously check the site. Okay, so now we're going to talk about paying employees because federal law governs what and how to pay, and then state law governs when to pay it. So you have minimum wage, which is $7.25 per hour. And then state law says, okay, you have to pay them monthly or every other week or twice a month or weekly. I don't even think they do weekly anymore, but yeah. So that's the Texas payday law. Here's my practical lawyer tip. Hire a third party to do your payroll. The reason is you will save money, a lot of money, by doing that because there are such steep penalties for doing it wrong and you will mess it up. The government does not make this easy. Anybody that has seen the new W-4 form that you fill out at W-4 or W-2, I always get them mixed up, sorry. Anyway, whichever one it is that where you say, I think it's W-4, where you say, this is how much I want you to withhold from my paycheck extra or not, right? It used to be really easy. You could like add up, I have this many dependents. Okay, withhold 2, right? And it would automatically just do an amount, right? That's not the way it is now. And I cannot tell you how much time I have spent on the phone trying to explain to my clients how to explain to their, $10 or $15 an hour workers how to fill that out. And they just are totally bumfuzzled because it is so confusing. So if the government can confuse you, they will. And that's why I'm saying have a third party do your payroll because you will mess it up. It is not easy and the fines are a lot. But there's a bigger reason for having somebody else do your payroll, a third party do your payroll. It's because I have a lot of experience doing payroll because I've always done the payroll for my family business. I mean, when I was a little kid and we had those, this was before computers, right? So it was one of those things and you dialed how much the paycheck was and then you put the carbon copy paycheck down and then you did, and it like printed in and like actually slotted the check so that nobody could like change the amount on the check and everything. I can't remember, Paymaster, I think is what that was called. So I've done that and I've helped do payroll a long time. I have parents who don't like to give up control of the payroll. They believe in keeping control of it. So we've at least gotten it to where we've got payroll on QuickBooks. But up until the advent of TeamViewer, where I could dial in remotely and do payroll, I had to schedule my vacations around payroll, and you will too. And so you will, if you are doing your own payroll, you will never have another vacation again that does not center around when is payroll. I went to Romania with a client for a month, helping them negotiate contracts for importing wine. It was really rough. I had to like go tour wine estates. It was great. Anyway, and so I'm in Romania for a month with my client doing this negotiations and stuff. And there was 2 times in that month where I was up at 2 o'clock in the morning or 3 o'clock in the morning doing payroll for my mom and dad for the family business, because I'm the one that does it and they don't trust anybody else to do it. And so hire a third party, just do it, because it will make your life so much easier. So, okay. Exempt workers. These are, so this is the how much to pay. So exempt workers are bona fide executives, administrative professionals, etc., that are exempt from overtime pay. You don't have to pay them overtime. They have to meet certain tests regarding job duties. That's why it's bona fide executives. You can't just call them a manager. If they don't manage at least 2 employees, they're not a manager, right? And they have to be paid not less than $684 per week. So that's their minimum wage. Now, the salary cannot be reduced because of a variation in the quality or quantity of work if they show up to work, unless you have a policy in your employee handbook that says you're not going to pay for work days or hours that they don't show up to work. If they show up to work and, like, let's say on Monday for an hour, and then you're like, you have a fever, go home, you need to quarantine for COVID or whatever, or maybe you have the flu, go home, we don't want it spread. If you don't have it in the company policy that you're not paying for the rest of the week, you pay the full week because they showed up for an hour, even though they're sick the rest of the week. So you've got to have it in your company policy that if you don't pay for them to be off, even if they show up, right, for the week. Now, if they're ready, willing, and able to work, and you just don't have any work for them, you still have to pay them. Okay. So that's like at a massage, like a beauty place, like, or whatever, if they're your salaried manager or something, even if there's nobody there to do that, you still have to pay them. Like if there's nobody there and they're not having to work that day because nobody showed up to get a pedicure or whatever, you still have to pay them because they're ready, willing, and able to be there. Now, non-exempt workers are hourly. We typically call them hourly because it's a lot easier to calculate overtime if you pay them hourly, but you can actually pay them salaried if you want. But most people say non-exempt workers are hourly. But anyway, for all hours they work over 40 per week, you must pay them time and a half, 1.5 times their hourly rate of pay. You're only required to pay for time worked. So if they work 35 hours and then they take a vacation day, so you have to pay them for 43 hours, you pay them 43 hours at their regular rate of pay because they only worked 35, right? You don't have to pay that 30 or for the 3 hours above 40 because that was vacation pay, not work pay. But if they work 50 hours that week, you have to pay them 40 hours at, say, $10 an hour, if that's the rate you're paying them. And that is because it's easy for me to calculate. And then 10 hours you pay at $15 an hour. Now, you are not required in Texas to pay for breaks, holidays, vacation, or sick days. However, if you give them a break that is under 20 minutes or under, you do have to pay for it. So like if you give them a smoking break, one smoking break, and it's 20 minutes or something, you have to pay for it. If it's a 30-minute break, you don't have to pay for it, right? Anything over 20 minutes, you don't have to pay for. Don't do 21. Don't be a creep. Do 30 if you're going to give them a good break, like their lunch hour or whatever. Okay. Now, sick days is asterisks because of something I'll talk about in a minute. So minimum wage is $7.25, but you have to check city ordinances. And if you work with the government or whatever, you may have to pay more, like federal construction and service workers have to be paid $10.10 an hour. So you've got to check the laws about that. That's why you don't just assume that you know this, right? It may vary in your industry. So there's a resource for you. Now, there's a trend in cities to require paid sick leave. Dallas, San Antonio, and Austin have all tried it and issued ordinances that required that you pay a certain amount of sick leave to your employees. All of them have been ruled unconstitutional and contrary and in violation to the Texas payday laws. So far they're not getting there, but they might eventually get it. So should you pay them salaried or should you pay them hourly? Well, first of all, when you're establishing your employee base and figuring out who to hire, consult your attorney and also go to dol.gov. They have great job descriptions and stuff in there, and they will help you. It's actually a really good site. Develop an employee manual with your attorney's help, definitely. Now, I get y'all are starting out, so you may not want to spend a lot of money on an employee handbook. So go to NOLO and create your own employee handbook. It's a downloadable thing in a PDF that you can then create your employee handbook. Don't just use it. Don't. Buy it, convert it from PDF to Word. It's easy to do. Your formatting will be all messed up, but hire somebody if you don't know how to format anything, and go through it and read it word for word and see if that works for your company, right? Because it may not be what works for your company. You may not have some things, or you may not have the hours, or you may not offer the benefits that they say, and you may not be required to offer some of those things. So you may take them out based on that. So definitely read it. Now, if you have independent contractors, don't have them sign the employee manual. That's the quickest way to turn an independent contractor into an employee, is by acknowledging that they have to be an employee by signing the employee handbook. You have company policies that they have to follow if you need to have them follow anything. Okay. Now, make sure that you provide the employee handbook to any new hire, and each year have an employee sign and state that they've read and understand the employee handbook. They're going to say that they read and understand it, and they're not going to read it. They're only going to read, like I said, the only time they read it is if they get fired and they want to see if they can sue you. So sometimes, like if you're having company meetings on a regular basis, it is a good idea to spend 5 minutes of that company meeting saying, hey, we're going to go over some things that are in our employee handbook, just so that y'all know and are aware of them, and then address them at the company meetings, especially the important things. And that way you're really assured that they know what the employee handbook says. Okay, in an employee handbook, can an employer prohibit employees from discussing their salaries or from disparaging the company and managers and other employees, like on social media and stuff? No, they cannot, because that is interfering with their right to organize a union, right? So you cannot do that. That is a very quick way to get a huge fine from the NLRB. So make sure that you do not prohibit that. I've had instances where one of the litigators I work with was telling me that they had worked with a client. They were actually, when I was talking to him, I was asking him some advice for another client, and he said he was on his way to an NLRB hearing, and I went, oh my gosh, what happened? And he, without disclosing too much, he said that his client had asked a colleague or another businessman, hey, do you have an employee handbook? Oh yeah, here, you just use mine. And here they did. Well, that person had not updated their employee handbook in probably 20 years. And it used to be that you could keep them from discussing their salaries. And so of course, somebody who got fired read it and went, oh my gosh, you can't prohibit that. And so then he got the NLRB involved. And I said, oh, wow, are you going to be able to get them off? And he said, no, I'm not even trying to get them off. I'm just trying to get them to pay under $70,000 in fines. So that's why you've got to really pay attention to what's in that handbook. Okay, you protect your company through non-competes, confidentiality agreements, and workplace posters. All of those are enforceable. Now, workplace posters, you have to have up. If you have a virtual company, you have to have a way for those workplace posters to be visible to your employees, even if they don't come in. But otherwise, they've got to be somewhere that they're visible, usually the lunchroom or some place that all employees have to go to, okay? do yourself a favor and make sure that you fill them in. I've gone to a lot of employees' locations and said, where are your workplace posters? And I look and nothing is filled in. Like those are made so that you can take like a Sharpie and fill in the blanks or check what applies. So you need to make sure that those are filled in. Also, make sure that they're up to date. The TWC updates their posters several times a year. And if you do not have update posters, you will be fined up to $3,500 for not having updated posters. And there are about an army of about 1,500 TWC workers in the DFW area that their sole job is to walk into places and say, show me your workplace posters and see if you have them. So I often tell people to make sure that you have them correct. And if you have a payday company, a lot of times you can pay them to keep your workplace posters up to date. And they will do so for a small fee that is absolutely worth it because your time is worth more than that. So, okay. Cell phones, make sure you have a cell phone usage policy. They can't text, etc. during if they're driving for work. You have to keep up with the technology. It used to be enough that you put a sticker on there saying you can't use the phone while driving, don't text. But now you've got to have apps that block those calls while they're driving. So make sure that you have those and a policy that they pull the car over. Here's a huge tip, especially if you have salespeople. Always provide a work cell phone for employees and that if they need it for work, and never, ever, ever let employees use their personal cell phone numbers for their work. Don't do it. And the reason why I say this is because it's an easy way of handing over your customer base to your competitors. And I know this because when I did my chocolate company, I first went to one packaging company and I met Mike, who helped me with my packaging, did a great job, loved it, everything. When it came time for me to reorder, I called the cell phone number that I was trained to use because it was on his business card. And so I used that and I got him and I said, hey, I need to reorder. And he's like, oh, I'm no longer with XYZ company. I didn't like the way they were treating their customers. I'm with ABC company now. And, you know, it's a better product. I really think I can do much better job for you now. Guess who I ordered with? Mike at the new company. Now, if they had required and had not put his personal cell phone number on his business card because it was convenient so that they didn't have to pay for cell phones, right? The conversation would have been me calling that number that I was trained to call, and Sally answer the phone and say, oh, I am so glad you called. Mike is no longer with the company. And you were on my list of people to call this week. So I'm really glad that you have called and I am so happy to help you. What can I do for you? And they would have kept the client base. But instead they handed over a ton of clients to the competitor simply because they were too lazy and too cheap to buy cell phones for their employees and specifically for their salespeople. Okay, internet and computer usage. You know, if you want to monitor their internet usage, which I do recommend, you need to have that in your handbook that they have no expectation of privacy of anything on the internet or any emails, and that you reserve the right to review any of their internet and email use as well as their phone use if you have phones for them, if they get laptops or iPads or whatever, you know, tablets, those. You need to make sure that screensavers, et cetera, are not offensive. If, you know, I've seen issues where like, you know, Sally just got back from Hawaii and she puts up a photo either in a frame or maybe like, you know, Joe, her boyfriend, puts it up as a screensaver on his computer and she is in a postage stamp bikini that is totally inappropriate. You need to say something as soon as you see it and get it taken down. And I apologize, I'm going to go maybe 10 minutes over, but I promise it's very important. So I apologize. I haven't done this in a while, so I didn't realize I added more. Anyway, So monitoring emails must be either in the ordinary course of your business. Well, who has time for that? Nobody. So instead, you have to have the express or implied consent. That's where it comes in. If you put it in the employee handbook and they sign it every year that they've read and agreed to it, whether they do or not, they've signed it. So they have express consent, right? Okay. Sexual discrimination or harassment. This is how to do an investigation. And this is very important because in a minute, you're going to see how our laws have changed in Texas significantly and how they are really bad for the employer. So this is super crucial. Okay. So sexual discrimination or harassment, you have to have a sound policy against harassment, which includes discrimination based on sex, race, color, religion, national origin, age, excuse me, hold on, I always forget that one, or disability. Oh, making sure that one. Anyway, this is Title VII, right? You have to enforce this policy diligently. You have to be proactive. Like if you find somebody is, calling people discriminatory names about their color or their religion or their race or their origin or age or whatever, like, even something as much as old man, right? That can be age discrimination. So you want to make sure they're not harassing people for that, or harassing them because they're too young. Like, oh my God, you weren't even born when that happened, right? And some of the jest is okay, but if it gets to be too much, if it's constant, if they like nickname the person and the person's, some people are like, oh, I got a nickname, they love me at work, and others are like mortified that they got a nickname, right? So you've got to be sensitive to it. And if they get a nickname, you've got to pull them in and say, is this a problem for you? It's totally okay if it is. I will nip it in the bud if it is. Not a problem, we'll do it discreetly, right? Okay. So be proactive in enforcing the policy. Don't wait for a complaint. If you see something, get it taken care of ASAP. Don't wait for somebody to complain. Take action as soon as you're aware of that problem and investigate all claims and complaints. Now, oops, sorry. Apparently that didn't do. Don't know why. There we go. Okay. Now, once you're investigating the claim, like say Sally comes to you and says, Joe grabbed my butt, touched me inappropriately. He's been, saying, hey, I'm in an open marriage, or hey, want to go have drinks, we can see if we can get a hotel later, or whatever it is, bring her in, listen to the complaint, and stay neutral, and don't validate the claim. You don't go, oh, Joe said that, oh my God, that's awful. Instead, you're like, okay, I'm going to take notes because I want to make sure that I get this right. Okay. So you take notes. Okay. And what else did he do? What else? Is there anything else? Right. So you just remain calm. Take down a written statement from her and have her sign it, or him. I actually have had to fire women for sexually harassing men. So it's both sides. But take down a written statement and have the employee sign it for accuracy and completeness. Literally, it says at the bottom, this is accurate and complete. Now, assure the employee that you will investigate and take action if it's necessary. Okay. Call your legal counsel immediately, right after that. You need then to meet with your legal counsel, may want to meet with her as well and get the statement. But you need to meet with key individuals to investigate the complaint. Okay. If you're investigating Joe and somebody says, well, Bob did that too, now you got to expand it. You can't just confine it to just Joe. And then once you find what's happened, you need to take appropriate action if you determine the claim was valid. Appropriate action depends. And it can be a wide variety of things. It could be warnings, disciplinary, you can demote them, you can transfer them, you can not pay them a bonus, you can terminate them. It really just depends upon how egregious it is. If you think you can turn the person around, is this person uncomfortable around them? Can they apologize? Can they work it out? That type of stuff. You cannot retaliate against the person that made the claim though. Now, carefully document your findings and your actions and institute training if a pattern is found. or if there's ignorance about the subject. So you may have to train them, like, this is not acceptable at work, right? So now here's the new Texas law. This is with regard to sexual harassment only. This is not race discrimination, religious discrimination, anything like that. It's sexual harassment only. So this is kind of the result of the Me Too movement. And it was hastily passed and very quietly. Like, I've talked to a ton of people that don't even know this exists. So the time to file an administrative claim with the EEOC and the TWC for any claim that occurs before September 1st is 180 days. But in Texas, after September 1st, for any claim that occurs on or after September 1st, the employee will have it will have 300 days to file with the TWC. It will still only have 180 days with the EEOC. Okay, so that significantly expands the length of time that they have to file a claim under what's traditionally thought of as Title VII, sexual, but for sexual harassment. Right now, if it's for race discrimination, religious discrimination, harassment, that type of stuff, age, you still 180 days. But for sexual harassment, it's 300. So lengthens that time. Here's the bigger thing. It used to only apply for employees that had 15 or more full-time, part-time, or on leave employees. It now applies to all businesses that have one or more employees. One or more. So if you hire somebody, you are now subject to this. It used to be that small businesses were not subject to this because most small businesses cannot handle, a sexual harassment claim that is going to bankrupt them a lot of times. So that's a problem. Okay. So now instead of 15 employees, it just applies for one or more. Now, it applies to any person. This is the other thing, is it used to be that it was just the company was liable for sexual harassment. But now any person who acts directly in the interests of an employer in relation to an employee. Thus, supervisors, managers, human HR professionals, other employees, and third parties, including independent contractors, may be named individually as defendants in the suit or complaint. And those persons can be held personally liable for damages. So in my other class where I say, oh, there's no personal liability if you form an entity except for in these certain situations, well, this is it. And here's the big rub. So hold on, let me see where I got to figure out there we go. Okay. It used to be that you could be liable for the sexual harassment if you knew about the conduct and didn't do anything about it. And there was a defense that said, hey, we found out about it. As soon as we found out about it, within a reasonable time, we implemented an investigation and we took action. And that was a defense. That's not anymore. This imposes liability if the sexual harassment of an employee occurs and the employee or its agents or supervisors know or should have known. That's the big key, that or should have known that the conduct constituting sexual harassment was occurring. So it's no longer if you knew about it, like you had the objective of like, yes, I knew, right? Like then you're liable, not personally, but the company was liable. Now there's this subjective of you should have known. Like if you had the proper things in place, you would have known. Oh my God, that's like huge. It's opening up a huge area for liability here. And if you fail to take immediate and appropriate corrective action. So you can't just sit back and go, okay, well, okay, this is Friday, we'll deal with it on Monday or Tuesday. No. After September 1st, you find out about it, you go investigate it. I don't care if it's 10 o'clock at night, you've got to start investigating it. Literally, that's it. It's like immediate and appropriate corrective action. Now, probably if you're not open at 10 o'clock, you're not going to start doing the investigation until the next morning, but literally the next morning, you've got to start investigating. It's crazy. This is a law that is going to be litigated out the wazoo. It's going to be figured out in the courts because it's very poorly written. It implements this subjective should have known standard, and it causes people to be personally liable. So what should you do as an employer? The first is you've got to review your policies, employee policies and handbook regarding discrimination. Consult your attorney, make sure that they comply with this new law. Establish a clear process for reporting complaints and behavior that the employees observe, and make sure that the employees know that they need to do that. So it's another thing where it's like, you got to tell, right? And so it's going to affect workplace. You know, people are going to be like, oh my God, what if I like compliment somebody on like their dress? Am I going to get sued for that or what? You know? And then implement sexual harassment training for all employees. They need to know what they can and cannot do. So, you know, you've got to make sure that that's done. Now, if you've got 1 or 2 employees, that may not be necessary. You know, it's what's appropriate for your business, but you definitely need to make sure at the very least that your employee handbook has the proper procedures in there for reporting problems, etc. You know, you need to make sure that employees feel comfortable coming to somebody. And if they, you know, you've got to have a process, like if you can't go to your manager, who do you go to? Like there's got to be written who to go to. So that's it. Okay. Now, I have not hit on a lot of things because most of y'all are starting your business. You maybe have 1 or 2 or 3 employees, maybe a few more. So I do not cover the Family Medical Leave Act because it only applies if you have 50 or more employees, full-time, part-time, or on leave, except of course for the COVID regulations. Those are only applicable through September 30th, I think, right now, and they're optional anyway. If you need information on that, I'm happy to answer it. But it basically says that, you know, you can get tax benefits so basically if an employee is out on COVID leave for taking care of somebody who has COVID or doing childcare because their schools aren't open or whatever, you have to pay for up to a certain amount of time, a certain amount per week, and the government reimburses you via a tax credit on that. Okay, so that's doable. OSHA, I can't even begin to address because everybody has a different type of business. And so OSHA applies differently for a construction company as to, you know, a yoga company, like a yoga studio. So I can't even address that. ADA, the Americans with Disabilities Act, applies if you have 15 or more employees, full-time, part-time, or on leave. So I usually don't address that. And the ADA is very specific. The only thing I can tell you about the ADA is if you have 15 or more employees, you need to make sure that if someone comes to you with like a severe allergy, like they're allergic to peanut butter or something, or if they are, you know, they have a disability of some sort, you have to make what's called a reasonable accommodation for them. If you can't reasonably accommodate them, you do not have to hire them, or you do not have to keep them on as an employee. So it just requires a reasonable accommodation. Talk to your attorney about what constitutes reasonable. And then the other one is Age Discrimination and Employment Act. It means you can't discriminate against people 40 or above. Apparently 40 is old now. Now I really feel old. Anyway, but if you have 20 or more employees, it applies. Before that, discriminate away. Not really. It's not good to discriminate at all, obviously, but those are things like Title VII doesn't even apply unless you have 15 or more employees. That's for a reason, because you know, small businesses need to be able to hire people quickly, etc., and they may not be able to, they can discriminate if they need to. I don't recommend it. Like I had a dentist, this dental hygienist called me up and she wanted to sue her dentist that she worked for because she told him she was pregnant and he fired her immediately. He fired her because he needed to replace her because she was planning on being out for maternity leave for like 3 months or so, and he couldn't be without a dental hygienist for that long. My first question was, how many employees does he have? And she said, oh, there's like 5 of us. Like, sorry, can't do anything for you. He can discriminate. Now, it wasn't very smart because the new hygienist, when you're in the dental office and you're getting your teeth cleaned, what do? You've got your mouth wide open and you ask a question. What happened to Sally? And then the new dental hygienist, oh my God, you would not believe she got fired because she was pregnant. Da, 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 da. He lost a lot of clients or patients that way. So it's not a good idea to discriminate. I think you should just be on the up and up with regard to that with your business from day one, but it's totally up to you as to how you want to do that. I've got another cat that has said hello. This would be Hattie. Hello, Hattie. Anyway, okay, so we are done, I think. Let's see. Yes, we are. If you'll email evaluations or feedback, or just let us know how we're doing on these. If you enjoyed the class, let Betsy Coulter know. If you want to become a client, this is how to do it. I highly recommend the SBDC. I've got clients that have used them for 15 years or more because they get a lot out of it. So that's it. I think we're done. If you have any other questions, I'm happy to entertain them. You can just either type them in the chat or you can unmute yourself and ask the question. Totally fine. If you have questions that you want to ask more privately, feel free to email me your question and I'll respond back. Usually that's at like 2 a.m. when I can't sleep. I'll get on and start responding to questions, but it may be a couple days before I get to it. So, okay, hold on. I've got to get this chat over because I got it out. How do I feel about the sites like Delegated for hiring virtual assistants? I'm not sure about Delegated. I know that there are sites where you can hire a virtual assistant that's over like in the Philippines for about $5 to $8 an hour. That can be a good thing. It can also be problematic because realize they are typically not working on your hours. Sometimes there's language barriers, but I also do know a lot of people that do very successfully hiring people over in the Philippines or Taiwan or wherever as their virtual assistants. So it can work. The one that I actually use and recommend is superpowershq.com. I'll type it in here for you. Let's see here. So it's like Superpowers headquarters. The reason why I like this is because those virtual assistants are specifically trained to support entrepreneurs. And so they are there to get you organized and to help you work on the business instead of in the business. And I'm a big believer in being a business owner that works on the business, because those are the business owners that can go to Fiji for 6 weeks and the business runs really well without them, versus somebody who works in the business and creates a job for themselves. And Superpowers HQ may cost you more money, so you may not want to do it right now, but it may be a goal of yours to do it. The people that are using that say it is fabulous, phenomenal, and amazing. And they have never had a vacation where they didn't think about business until they finally got a Superpowers HQ assistant. They just know how to support entrepreneurs and they do it really well. They're trained in the strategic coach methods, so they're very good. If you don't know Dan Sullivan, strategic coach, highly recommend it. He teaches, it's not cheap though, but he teaches business owners how to have a self-managed business so that you can go take your vacations. Okay, so let's see. it used to be Red Butler, and they hire college educated assistants. Oh, that's good. That might work. Yeah, I'm not against doing virtual assistants. I think they work. You have to get in a rhythm. You have to be very careful about how you instruct them on what to do. You need to make sure that the agreements that you sign with them require that they have confidentiality, because you don't want them disclosing your confidential information, and that type of stuff. So you really need clearly defined of what they're going to do for you and how to do it. And you need to be a good delegator and efficient on that. Yeah. Other questions? If a company received a PPP loan, is it important to know that these companies for virtual assistants are located in the US and not outside of the US? I'm not sure I understand that. So the PPP loans didn't have anything to do, I don't think, with how many employees were located in the US or outside of the US. It was more to help the companies that had to lay people off or couldn't afford employees at that point to be able to afford them to bring them back to work. I don't know about the outside of the US, because all of my clients employ people within the US, and their PPP loans were based on that. I can't remember. It's been over a year since I've helped fill out those applications. I can't remember whether they had I don't think they distinguished whether the employees were in the US or outside. It just said total number of employees. So I don't know. Interesting. So other questions? I'm serious. Y'all can unmute if you want and talk. That way I actually know y'all are real people. Well, if y'all don't have any other questions, then we are good to go for tonight. Oh, any CPA referrals? Yes. So if you will email me, my email is plastered all over the place. So is my Facebook, because that's where you can get good information. So follow me on Facebook, not because I want more followers, but because it will help you in the long run. I don't post that often because I just don't have the time, but when it's important, I do post. Anyway, if you will email me and say, send me your referral list. I don't take referral fees. I just have a referral list of good people that I recommend that know their stuff and provide good customer service. And my clients all rave about them. That's how they get on my referral list, is my clients usually have told me, oh, this person's great, I love them. And then they get on my referral list. So I always have second confirmation. Like I always have outside confirmation, instead of just like somebody asking, hey, can I get on your referral list? That's the quickest way to not get on my referral list. If somebody recommends you, if I talk to you, I know that you know your stuff, then yeah. And anyway, so I have this referral list. Just send me an email and say, send me the referral list, and I'll send it back to you. I have CPA referrals on there. I've got banks who do great SBA loans and don't treat you like a number, like the bigger banks do. I've even got, well, I had a personal trainer on there for a long time. I don't think I have him anymore because he moved. I've got a printer on there. I've got a logo person. I've got so graphic artists or graphic designers on there. And I update it regularly. So, if you find that I need to update a phone number or an email because you can't get a hold of somebody, let me know, because sometimes they forget to tell me. So that's it. All right, y'all. I really appreciate you sticking with me, even though I ran late. I apologize for that. This new sexual harassment stuff just has me totally discombobulated, because that is really changing a lot of how the workplace is going to work and your liability. So I wanted to cover that. So anyway, thank you very much. And I am going to go ahead and stop screen sharing, and then I'm going to go ahead and just end the call. So thank you very much. Y'all take care.